My name is Patricia Haren, and I am a family law attorney. Many clients will ask, my circumstances have changed since I agreed to the parenting plan in my final judgment. Can I make changes to my parenting plan? Many times the parties will come to an agreement during their divorce, or the court will make court orders, and that judgment works for the ages and the stages that the child is currently at when the divorce is finalized. Most judgments provide that the parenting plan and custody and visitation orders are intended to be full and final orders of the court. Therefore, in order to change custody agreements or judgments, you will need to show that there has been a significant change in the circumstances since the time the judgment was entered. Those changes can be the arrest or substance abuse of one of the parents, which could be grounds for a change in custody. One of the parents may choose to move out of the area, and it may not be practical to have the parenting plan remain in effect given the location and the move of that parent. In other circumstances, the child may be undergoing significant mental health or emotional issues, and it may be under the recommendations of the therapist to have the parenting plan changed. The parent that wishes to change the final custody orders will have the burden of proof to show that there has been a significant change in circumstances, enough to warrant a change in custody and visitation. If you are seeking to go to court to change your custody orders, you want to make sure that you're gathering all of your evidence prior to the time you file a request for order. If there are arrest records or hostile communications with you and your former spouse, you want to gather that information. If the child has been seeing a therapist, you'll want to see if the therapist is willing to testify in court or at least provide you with a written document so that you can present that to your attorney. If one of the parents is seeking to move, you want to outline what parenting plan you feel is going to be appropriate after that move. Sometimes a child will have started a new school, or the parents may have a new work schedule, and those schedules may not be conducive to the current parenting plan. For example, if a parent has difficulty getting the child to school on a daily basis or has difficulty in completing homework with the minor child, this could be considered to be a significant change in circumstances. You'll need to get the appropriate information from the school and from the teachers so that you are able to present your case to the judge. We had a case where the child resided primarily with mom during the week and dad had alternating weekends and one evening visit during the week. In this case, the mom was unable to get the child to school on time, so the child had several tardies and also excessive absences. The school district had required both the parents and the minor child to attend a truancy hearing on these issues, and they presented both parents with a copy of attendance and tardy records. Our client brought these records into our office, and we learned that mom was suffering from a substance abuse issue, and therefore was often sleeping when it was time to get the child up and take the child to school. We were able to file our request for order for modification of custody, and our client was awarded primary custody during the weekdays and supervised visits to mom because of the substance abuse issues. This enabled the mom to be able to go and get assistance and go to treatment for a substance abuse issue. This benefited our client, the mother of the child, and most importantly, the minor child. If you have any questions about whether your parenting plan should be changed, shoot us over an email or give us a call.